Your right to an attorney. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine scale form PC 628. This is a scale form, State Court Administrative Office, PC for Probate Court, Form 628. It is used in very particular circumstances in the probate process in which an individual is entitled to the appointment of an attorney through the state. So this is different than an attorney that is being privately retained, in which that attorney would file an appearance with the court. This form is used by the court when an order is being entered appointing an attorney on behalf of another individual. With all of the state court administrative order forms, one of the nice features is at the bottom corner of the form where the floating highlighted arrow is, it tells you what statutes and court rules apply to the particular form. And in this particular case, this is not a form that an individual would generally prepare and fill out. It generally originates from the court itself. So, as part of the court process in which an individual being sought protection over is entitled to an attorney, in those particular circumstances, the court would use this scale form to appoint an attorney. And often these attorneys are on qualified lists within the county. They've been gone through some form of training, typically through the court's process, to be qualified to become an attorney to be appointed. That's typically the way most counties function. The attorneys being appointed have some general experience or extensive experience in the particular area upon which they're being appointed to be an attorney on behalf of an individual. So let's work our way through the form and understand the context and use of this form, the Order Appointing Attorney. In the top left corner, it would identify the county in which the matter is proceeding, and the top right corner would be the case or file number. The top part is pretty intuitive. It identifies the name of the estate, the date of the upcoming hearing, and the judge that has been assigned to the docket. Now, this is, if you receive this form in the mail, it's important when you see the date of the hearing to understand that there's an upcoming hearing, to make sure that you're calendaring it. So if you're the recipient of this form and you're aware that an attorney has been appointed and you weren't aware of a hearing, please make sure that you calendar that date. Now, with all of these scale forms, it's really important to not navigate through the probate process, through guardianship, conservatorship, mental health, or deceased estates, without the assistance of a qualified, experienced probate lawyer to be able to explain the language, the process, understand those court rules and statutes that I've referenced here below, and as well as the greater body of statutes. So here it identifies under number 2 that a proceeding has been filed with the court involving the individual named above, and it appears it's necessary to appoint an attorney. So let's give some examples. It could be a guardianship proceeding in which the individual is being sought guardianship over, and when the guardian ad litem goes out and does a visit to see if they're consenting to the appointment of a guardian, the individual says, no, I don't think I need a guardian. Or maybe they say, I don't think, I may want a guardian, but I don't want the person that's being nominated. Well, there are certain statutory rights for that individual to have an attorney appointed by the court. And this is just one example. But in not all examples are you entitled to an attorney. So what I mean by that is there are many scenarios in which we get called and they say, well, aren't I entitled to the appointment of an attorney? And the answer is no. There are very specific defined instances in which an attorney gets appointed by the state. Otherwise, you have to go out and privately retain an attorney, or go improper, which means do this without the assistance of an attorney. So in this particular case, in the context as referenced in those statutes below, those are circumstances in which an attorney may be entitled to be appointed on behalf of an individual. Now, this section is pretty also intuitive. It's identifying, it is ordered, number 3, and it states the name of the attorney that is being appointed, the attorney to represent that individual. And it says, in proceedings in this matter until discharged by the court, which means it'll remain on until the court says you are discharged. Now, if the court appoints an attorney for you, you have every right to still hire your own attorney, to privately retain an attorney. So again, this is, you're being afforded a benefit through the statutory provisions, but you have every right to privately retain an attorney and substitute that court-appointed attorney out. Number 4 states that the individual that was the guardian ad litem is now being discharged. So often this is the context. Let's understand the general context upon which this form is often used. A petition for guardianship is filed. Somebody is being sought guardianship over. A guardian ad litem who reports on behalf of the court goes out and does a visit and ascertains whether the individual being sought guardianship over is a person that consents to the petition being requested, consents to the need for guardianship, consents to the person that's being appointed for them, or they object. Or maybe they indicate that their assessment of the circumstances state that the person doesn't need a guardian, that maybe the guardianship petition was being filed improperly. So under those circumstances, the guardian ad litem gets discharged by the court, and the court then appoints an attorney. The guardian ad litem and an attorney are performing very different roles. The guardian ad litem is looking out for the well-being of the individual, but is reporting to the court. The attorney has a duty directly to the individual, not to report to the court, not to be a reporting device or a mediator of the issues, but rather to have a duty to one, and that is to the person that they're being appointed over. On the bottom section of this form, the judge would sign there, and then if there's an attorney involved in the matter, the attorney's information is there. So again, this form is used. It's generally not a form created by an attorney or an individual, but generally by the court. And again, if you're involved in these types of proceedings, we strongly urge you to work with a skilled, competent probate lawyer. At the Probate Pro, we're passionate about everything probate. If you have questions about this particular matter, a probate proceeding, guardianship proceeding, or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.